Minister Zadić, dear members and friends of the European Law Institute, it's a great privilege for me indeed to be opening this year's ELI Annual Conference. And yet I have to confess that I am doing so with mixed feelings. When we planned to have our annual conference in Budapest, and when our Hungarian hosts, under the great leadership of the Eötvös Loránd Law Faculty, began planning a splendid meeting in one of Europe's most beautiful capitals, none of us ever faintly foresaw what was lying ahead of us. We all wish to be in Budapest now, and we would like to thank the organizers of the Budapest conference for all their efforts and their endeavors, and for the wonderful cooperation we had with them. And yet, everything changed. 2020 was an extremely unusual year. And I already mentioned at the membership meeting that we received many messages from ELI members who suffered from the crisis. We have heard from ELI members who were in hospital, who lost their beloved ones, whose relatives worked as doctors and nurses and were heavily affected by the catastrophe that hit Europe without us ever thinking that something like this could happen in our continent. We know of many ELI members that were hit by economic distress. And those messages, some of them were really, really touching, and there were really emotional moments for all of us. It was then, in the face of this crisis, a really difficult decision which the ELI leadership had to take with regard to the ELI Annual Conference. We had to take a decision in early summer whether we hold this event, whether we move it online, or whether we cancel. Honestly, canceling was never an option. We found it is so important for us to meet and discuss our current work that we didn't really consider canceling like many other organizations did. However, it was really a difficult decision for us, whether to take the risk and have a physical meeting in Budapest, or whether to go for an online meeting. We knew very well that we had to take the decision very early, because preparing an online conference is not an easy thing. It needs months of preparation. And all this preparation has been done by our wonderful secretariat and our wonderful staff. So there we were in early summer having to take that decision. And we didn't take it lightheartedly. At the end of the day, it was the many emails from members that reached us, telling us that unfortunately they are a member of a so-called COVID risk group, and that for this reason they may not be able to join us. There were also other members who wrote to us that unfortunately they are living in a country that has been hit more than others, and that for this reason they foresee difficulties joining us. And we believe that this is an organization that is built upon the spirit of collaboration, of diversity. And we thought it is not a good idea to meet in a place and know upfront that we will exclude many of our beloved colleagues, those who belong to certain age groups, those who have a medical condition, or those who come from particular countries that are hit by the crisis more than others. What made it difficult for us was the other emails. The many emails we saw where colleagues were already announcing that after the pandemic is over, we will all meet in Budapest. The European legal community will come together in Budapest and jointly, hopefully, celebrate that we have overcome the crisis. We really loved these emails because these emails showed us that the ELI has, during the 9 years of its existence, achieved much of what it had tried to achieve, which is help build up a vigorous European legal community, a true European legal family, with everyone truly looking forward to the next family reunion. So here we were, with all these conflicting messages and all these conflicting wishes, and many of them were really touching. Now, how could we ever take a decision? At the end of the day, we took the decision to not take a risk for the health of our members and to move online. And sadly, I have to say, it was the right decision. Of course, we all would have loved to come together physically, but it's not possible. We are seeing a second resurgence in several countries. We see the reintroduction of quarantine requirements, and recently Hungary more or less closed its borders, so it would not even have been possible for us to enter the country. So sadly, we took the right decision. So we're immensely grateful to all of you who have shown their understanding and who are joining us now remotely under these new circumstances. COVID didn't only change the format of our annual conference. COVID also changed many of the ELI's activities. 2020 would have been the year when we had planned several trips to 3 other continents, to tie new bonds and to make sure ELI has a good working relationship with organizations all over the globe. It would equally have been the year where we planned to visit many of our institutional observers and the individuals that had only recently been elected into their new positions in Brussels and elsewhere. When it became clear that all this would not be possible, we switched to online meetings. This proved to be a good option, in particular, where you already have close ties and a good working relationship from previous years, such as with Commission Vice President Jourova. And I'm particularly happy that it was possible to have online meetings with both speakers of tonight, Minister Zadić and Commissioner Reynders, who will join us later in the evening. But of course, meeting online is not so much an option when you have never met your counterparts before, as is mostly the case for institutions, in particular in Asia and Africa, which we would love to have closer ties with. We currently hope that we can have most of these meetings in 2021, though it is extremely difficult at the moment to engage in any planning. Very soon we began to make the best of the situation, as everybody else did. There was a flow of emails that encouraged us to carry on. I still remember Christian Twig-Flesner recommending everybody to start washing their hands against the melody of Ode of Joy, and similar recommendations to make the best of the whole situation. We all turned to digital, and suddenly we saw colleagues more often and all sorts of times at the day and in their living rooms. So everybody's speaking of social distancing, but in a way, it also meant coming closer to one another. In fact, COVID has revolutionized the way this organization is working. Many of our project teams have met digitally, and we're immensely grateful to them for having carried on their work. Our executive has been meeting regularly at a distance. And in fact, this has also revolutionized the way we have our discussions and we take our decisions. Yesterday and this morning, we had a remote council meeting. And even though everybody agreed that physical council meetings are important, there was still a unanimous view that it could be extremely useful and beneficial for this organization to meet more often and to do so remotely. Don't get me wrong, this organization will not become a virtual organization. We all agree that it's so important to meet each other in person, but still going digital could be good here and there. It helps drastically reduce our ecological footprints, and it also provides for more diversity, as it is a good step to engage also individuals whose professional backgrounds or family situation or health situation would normally not allow them to come. And we believe that this is so important because it's important to keep the ELI going. We believe that the COVID situation has made this organization even more important. COVID has been a challenge for the European vision. We have seen something we had not seen for decades, borders between countries being closed, European member states stopping lorries with much needed medical equipment from leaving the country and providing supplies to other member states. We have seen states taking all sorts of steps that can be seen as a singular national path and moving away from what we perceive as our joint European vision. We have seen governments taking the opportunity of enhancing their powers, possibly at the expense of elected parliaments. And in my own country of residence, Austria, we have recently heard a right-wing party announcing that they may base their next election campaign once more on a proposal for Austria to leave the EU, after they had always beaten their head against the wall with such ideas in previous campaigns and taken a U-turn at the last moment. Luckily, there's enough strong EU support in the population not to allow such things to happen. But still, in the light of all this, the ELI leadership believed ELI cannot remain silent in this situation. We had a discussion about how to best react as an organization to all these developments. And as a first step, we developed jointly the ELI COVID principles as a guidance for the European states how to cope with the crisis. We were very hesitant at first when we took this step. Does it really provide added value? Is it really for this organization to do so? But it was the overwhelming positive feedback we received from all sorts of parties that at the end confirmed it was the right decision. We received messages from legal journals from all over Europe, whether they can publish our principles. We received requests to translate the principles into various different languages. We received letters from all sorts of international organizations and EU institutions congratulating us on our work. And indeed, those relationships will probably be of a longer duration, and we will engage in a debate and in a discussion on how to best cope with the crisis. The COVID principles also then resulted in a series of ELI webinars on the COVID crisis. And again, we're extremely grateful to all ELI members that participated in those webinars, and that made it a special occasion and a special way of engaging with the European public. Now, luckily, we have seen the atmosphere changing again recently in Europe. We have seen a Europe that can take rigorous action against the crisis. And it's this positive momentum and spirit that is so important for all of us. And I'm sure it's also an inspiration for this organization on its way forward. This morning in the council meeting, colleagues discussed on how the ELI can contribute to a still more vigorous European legal community. And I quote Executive Committee member Friedrich Zoll for underlining the ELI's potential of becoming an important, I quote, integration power and of developing, again I quote, a united Europe concept. And I believe it is really in this spirit that we have to develop this organization further. It is in this spirit that the ELI is going to hold its annual conference with online webinars on a variety of topics, ranging from artificial intelligence to corporate sustainability. And I would like to take the occasion to thank all those partners of the ELI that are making this work possible. Of course, all our members, all our individual members, as well as the institutional observers that are so important for us. But mainly, I would like to thank the University of Vienna, its rector, the Dean of the Law Faculty, for the enduring support. And I would like, and I think Commissioner Reynders has meanwhile joined us in the background, I would like to thank the Directorate General for Justice, the European Commission, for supporting this organization. And this is so important for us to be able to really pursue our work. But let me now turn to introducing an important alumni of the University of Vienna, Minister of Justice Alma Zadić. Alma Zadić was born in Bosnia. She came to Austria when still a child. She studied law and did her PhD in Vienna and at Columbia Law School in New York. After working for 6 years at one of the world's leading law firms, she went into politics, serving as a member of parliament, in particular on behalf of the Greens since 2017. And in January, she was appointed Minister of Justice. Since then, she has brought on track a number of really important initiatives, of which I would only like to mention measures against hate speech on the internet. Minister Zadić, we're really honored, and it's a privilege for us to have you here. And I would like to give you the floor. We're looking forward to your welcome address.
Dear Madam President, dear Commissioner, ladies and gentlemen, let me first thank you very much for this kind introduction. And I have to say it's my great pleasure to welcome you all to the annual conference of the European Law Institute 2020. I, of course, would have preferred to welcome you all in person today, but nevertheless, the circumstances do not allow us to be in person, to meet, to talk, to chat. But however, it's great and it's wonderful that the European Law Institute has managed to set up the conference in spite of this different situation, and that we are all able to exchange in this online forum. And so let me first also express my thanks to the Institute, and in particular to its president, Professor Christiane Wendehorst, for the efforts to make this event happen and for also inviting me to speak to you today. The topic of the conference this year could not be more relevant and even more important. Most recently, the COVID pandemic has shown us the importance of access to justice, independence of the judiciary, but also of how important it is to observe the fundamental principles of the Constitution. I'm therefore very glad to see that the conference will deal with many of those important issues. The pandemic, as you all know, has overnight posed great challenges to the executive process in the ministries, to the legislative process in the parliaments, but also in the legal system in general. And not to mention, of course, to all parts of the society. The drastic health situation that all of a sudden emerged at the beginning of the pandemic called also each of the countries for rapid legislative actions. With regard to the necessary restrictions of social and economic life, all countries were challenged with a very short time frame because they were challenged to strike the right balance between basic fundamental rights. Whether we should prefer health or should we prefer freedom, or how to strike the right balance was the big issue we debated almost every day. And in my view, I must admit, the crisis has explicitly demonstrated how the value and how valuable our fundamental principles are. It is essential also to realize how important it is that all the citizens can rely on the fundamental rights and on our fundamental principles. And one thing was particularly visible, and I would like to mention that, also that our constitution has shown that in particular in the times of crisis, it shows its importance, but also its beauty at the same time. Because we have seen how relevant it was to have fast decision-making processes, and our constitution allowed it because we had a parliament that took place very fast, that enacted very fast decisions. We had ministries that had to enact executive orders, but we also had a very fast judicial monetary system. And I think that's of the very importance that we should underline, that the rapid judicial monitoring was of utmost importance in this time of crisis. We have seen that the Austrian Constitutional Court within 2.5 months has rendered its decisions saying whether some legislative measures had stroked the right balance or not. And I think that was relevant. But the second point is also that we have seen that regular courts were also of utmost importance during this crisis. Because we have seen that during the lockdown, one thing we should not forget is that the courts remained open because it was necessary that the judicial system still was functioning. It was, for example, conflict and violence in the families. We have seen a rise of violence in families, and therefore it was important that the functioning of general court was still available and it was still operating. The independent judicial system through family law and violence and protection law provides protection to the most vulnerable members of our society. And that was also what our system showed during the crisis, that it is there to protect also the most vulnerable members of our society. But in times of crisis, cross-border cooperation, support, and understanding of each other and of the different approaches that different countries have is vital. Thus, if I look at the rich program of the conference today, it's great to see how many important and relevant issues we are dealing with during this conference. Take, for example, the session on the role of courts in family and succession matters. The European Union countries, the countries of the European Union, deal with conflict and violence in families and succession very differently throughout the countries. Different systems are in place in different countries, but any smooth operation of cross-national legal communication in matters of family and succession relies, of course, upon the awareness about such differences, but also upon an interest and willingness to draw greater knowledge and valuable suggestions from comparing different systems. And there are also many different sessions that the conference will touch upon that are of great relevance. For example, also take procedural law. The European Law Institute and UNIDROIT have already for some time dealt with procedural law in the context of the topic of uniform civil proceedings. The current project, for example, started in February 2014. And since then, many working group sessions have taken place concerning the various building blocks of civil proceedings. During the most recent session in Vienna in autumn 2019, collective redress was one of the very relevant, but also very hotly debated topics. And I must also say, in a political framework, it's a very hotly debated topic. And these results that came out of the conference, of the session in autumn 2019, were found, of course, very interested for the European Parliament, for the European Commission, but also were of high interest to the national legislators, because they are setting internationally recognized standards for cutting-edge civil proceedings. And in my personal view also, collective redress may be an important tool in many areas to simplify access to justice. Another session of the conference that is dedicated also to the future of contract law, and I would like to draw your attention to it, is blockchain and smart contracts, which can be potential tools for efficiently organizing contractual relationships and administrative structures. But at the same time, they also touch upon very complex legal issues. It is therefore important to closely observe the developments in the area in order to make the most out of the available technical opportunities, and of course to prevent the misuse at the same time. And this, of course, will require a well-founded basic work that has been provided by ELI on multiple occasions in the context of European law. And most important, these regulations, because they do act across all nations and across borders, these regulations should be uniform as possible. As, of course, the technologies are applied cross borders. And this is a classic area of responsibility of the European Union. And this is also a classic area which I'm very happy that it's going to be discussed during the conference. And another session that I would like to draw your attention to, because it's also close to my heart, is business and human rights, access to justice and effective remedies. The issues of corporate social responsibility is of growing importance, in particular in times of climate change, in times of an increasing disruption of the natural and social livelihoods. In the present crisis, we have realized how important it is for businesses to properly integrate the interests of the society in which they operate, of the workers, and of those depending on such companies. And it has to be acknowledged that ELI addresses the challenge of identifying well-balanced and practicable regulatory options. And I'm sure it will be a very fruitful discussion with many interesting outcomes, and I'm very interested to hear about it in the next days. And two more points I would like to raise that are also happening on Friday afternoon is EU conflicts of laws for companies. This is also of a political significance, in particular now that the United Kingdom is leaving the European Union. In the economic area, clear conflict of law rules are most valuable because they do provide a predictable legal framework for entrepreneurial activities. And they, of course, enable targeted decisions on behalf of business transactions. And I think that's also very important that these issues are being discussed, because in the very end, they are very relevant also for decision makers, for the legislative process, and for us dealing in the judicial system, dealing in the European framework. But from what I've mentioned so far, it's obvious why special thanks are owed to the European legal institutes, that this conference is being made possible under these circumstances. But also special thanks to all the representatives of ELI and to all the representatives of academia and interested parties who were working on these important projects and who will continue to work on these very important projects. In this sense, I wish you all a very interesting exchange during the 2020 annual conference. I wish you a stimulating and fruitful discussion, and I'm looking forward to hear about the good results and the solutions that you came up with, which of course will further promote and develop our European legal framework. Thank you all so much.
Well, thank you so much, Minister Zadić, for these really encouraging words. And we will, of course, be happy to report back to you any results of this conference and of the projects that are featured as this conference. I'm really looking forward to the exchange with the Ministry of Justice that has been supporting the ELI for so many years now. So thank you very much again, Minister, for your presence at this occasion and for this welcome address to our members that have meanwhile joined us. Thank you so much again. And it is now my great privilege to announce tonight's keynote speaker, Commissioner for Justice Didier Reynders. We are immensely grateful to the Commissioner for having made this keynote possible and for the very fruitful remote meeting and discussions we have had with him about a variety of issues. We are likewise very grateful to the Commissioner for having written the cover letter for the current ELI newsletter, as you will have seen. The European Commission is an extremely important partner for the European Law Institute, and we have together discussed avenues how to enhance our cooperation and to cooperate still more closely in the future. But given that the Commissioner is from Belgium and we have the luxury of a Belgian member in our executive committee, I will now hand over to Denis Philippe for introducing the Commissioner.
Thank you very much, Christiane. Dear ELI colleagues, it is a great honor for me to introduce this evening my compatriot Commissioner Didier Reynders. He began his career, like many of us, as an assistant at the Faculty of Law. His field of learning at the Law Faculty in Liège was public law, where he was very active. He has been a leading politician in Belgium for several decades. He has held the highest office of the Belgian state over the past 20 years. His intellect, wisdom, and political vision have taken him to the most important position which he has discharged with distinction. First, as Minister of Finance, then Vice Prime Minister and Minister of Foreign and European Affairs. He was also appointed to the important position as Chairman of ECOFIN. Mr. Reynders has introduced many very innovative reforms on tax law. He was a very successful Minister of Foreign Affairs. As a leader of the Mouvement Réformateur, he was able to enlarge the electoral basis of his party, which is now the second party in the French-speaking community. When I listen to him, I do so always with great attention, because what he says is always full of intelligence, understanding, and common sense. He was also a professor of European economic law at my university in Louvain, and my son has the privilege of attending his lecture, which he found very interesting. Commissioner Reynders is also a true and convinced European, like all of us. And naturally, he began his duty as commissioner with enthusiasm and vision. I had the privilege of listening to Commissioner Reynders at the speech he gave at the CCB early this year. His program was very inspiring. He already insists on the respect of the rule of law. I'm sure that he will also inspire the members of ELI. We are keen and eager to listen to you, and we will be glad to interact with him after his speech. I gave him the floor.
Do I need to start a video myself? Yes, it's true. Okay. Now, thank you very much. Thank you, Madam President, for your invitation. It's a pleasure to see you again after our meeting in June in Brussels. Thanks to Denis Philippe about such a beautiful presentation. Thanks a lot. It was a pleasure also to have many young people, also your son, at the university level. And of course, it was also a pleasure to see again the Minister of Justice, Alma Zadić, because we are working together Justice Council, but we are working also on some common issues. I'm thinking about, first of all, maybe the collective redress, because we have made some progress at the EU level during the Croatian presidency on the collective redress, and we are preparing now an initiative on the sustainable corporate governance. So again, we are on the same line maybe than the Austrian government on some issues. But ladies and gentlemen, it's a pleasure, of course, to join you at your annual conference. And I sincerely wished that I could have been present in person. Unfortunately, the situation obliged to go to a virtual conference, but maybe we'll have the pleasure later in the next months to have a physical meeting with you. The choice and range of subjects that you will discuss over the coming days impresses me. It's a sort of program also for the European Commission. Artificial intelligence, admissibility of criminal evidence in the digital age, data economy, access to justice and effective remedies, and the independence of the judiciary, among others, are all key topics of our society. And several of the topics that I just mentioned are relevant for the rule of law, which is one of the fundamental values of the European Union, enshrined in Article 2 of the Treaty on the European Union. In fact, the European way of life is the Article 2 of the Treaty with a reference to our values. What makes the rule of law so important is that it guarantees the respect of all other values, including democracy and fundamental rights. My conviction is firm. There can be no compromise when it comes to defending our common values. Without respect for the rule of law, there can be no functioning area of freedom, security, and justice in the European Union. Without respect for the rule of law, there can be no functioning internal market, where laws must apply effectively and uniformly. And the rule of law is also relevant to ensure that budgets are spent in accordance with the applicable rules. And without rule of law, there can be no mutual trust, which is crucial between member states, but also between citizens and economic operators. Trust in public institutions, including in the justice system, is crucial for the smooth functioning of our democratic society. I would like to stress that the rule of law is a well-established principle and well-defined in its core meaning. It can be objectively assessed so that shortcomings can be identified on a sound basis. The principles that represent the core meaning of the rule of law have been recognized by both the European Court of Justice and the European Court of Human Rights, as well as in the Council of Europe standard. So we have many references. The work of the Venice Commission provides us a useful reference in this regard. And the European Commission also relied on these principles in its 2019 communication on the strengthening of the rule of law in the Union. But as you know, recent developments in Europe, at least in some member states, have shown that the rule of law cannot be taken for granted. The concerns led the EU to put the rule of law at the top of its agenda. I'm also aware that in certain member states, NGOs and legal professionals are experiencing blows to their independence and effective operation over the past few years. These developments raise important questions which the Commission has a duty to address. In order to do so, the Commission already has at its disposal, you know that, several instruments in its rule of law toolbox. Such tools include, for instance, the country-specific recommendations in the European semester, or the EU Justice Scoreboard, which provides comparative information on national justice systems in the EU as regards their independence, quality, and efficiency. There is also the important possibility to launch infringement proceedings when EU law has been breached in concrete cases. In recent years, we have seen groundbreaking new case law of the European Court of Justice on the possibility to scrutinize rule of law violations in court. But it is clear that we need to do more and think outside of the traditional toolbox. Therefore, the Commission launched an important reflection process last year, which led to a communication in July 2019 focusing on three themes. First, we need to promote a culture, a real culture of rule of law among the general public. Second, we have to prevent rule of law problems from emerging or deteriorating. And third, response. We need to reflect on ways to react more effectively to significant problems once identified. President von der Leyen and our Commission are committed to carry this work forward. Today, I will focus on the prevention of problems that arise in the area of the rule of law. Indeed, a major focus of our rule of law policy is about prevention. It is about detecting and remedying rule of law issues at an early stage. To do so, we need a better understanding of the situation of the rule of law in the whole of the European Union. This is what the new comprehensive European rule of law mechanism, which the President of the Commission announced in her political guidelines, is all about. As Justice Commissioner, I have the honor to lead the Commission's work on this file. As part of this new mechanism, I'm coordinating the Commission's work on the first annual report on the rule of law, which will cover all the 27 EU member states on an equal footing and with objective reporting. This is one of the major initiatives of the new Commission. It includes monitoring significant developments, both positive and negative, in 4 different areas: the justice systems, the anti-corruption frameworks, media pluralism, and other institutional issues related to checks and balances. Finally, and where relevant, the report will also reflect recent developments with regard to emergency measures adopted during the COVID-19 pandemic. We are currently finalizing the 2020 Rule of Law report, and our intention remains to adopt it by the end of this month, at the end of September. We have a sound basis for our reporting. In particular, we have received written input from all EU member states and from over 200 stakeholders, including professional organizations and individual legal professionals. Our services also conducted more than 300 virtual meetings with all member states, but also with stakeholders and civil society. And we are currently consulting each EU member state on its country chapter to identify possible factual inaccuracies. So we are at the end of the process, but with a real participation not only of the member states, of the authorities, but also of the civil society. The rule of law report will then serve as a basis for the German presidency of the Council to quick start a genuine political dialogue on the rule of law between the member states in the Council. This political debate also needs to take place in the European Parliament, and I insist on this, in the member states, notably in national parliaments, but also with the civil society and other stakeholders. I can assure you that I'm firmly committed to this objective. The aim is to start a regular annual cycle and provide the impetus for the EU to address challenges for the rule of law in a cooperative way. This will notably help us to learn from one another's expertise and experiences and best practices, but also to identify problems early on. Our objective is also to promote the establishment of a rule of law culture across the European Union. It's maybe the most important element to be sure that we have the opportunity to install a real culture of the rule of law in the whole Europe, because it's that the only one way. If we have problems in one member state, we need to convince the public opinion and the population and the citizens in general that it's very important to take care of the rule of law. We say that it's very important because we have had the tradition at the EU level to discuss about structural reforms, pension schemes, social security issues, to discuss about the budgetary situation, but it's very urgent to start to discuss in the same way about the rule of law and our shared value. And we are trying to do that with such a first element, the annual report on the rule of law. But let me now maybe address another major topic of your conference. I mean the digitalization of justice system, digital transition for all the justice systems in Europe. The challenges related to access to justice in the digital age, which we are facing even more during the COVID-19 pandemic, make the discussions on digitalization more relevant than ever. By digitalizing our court systems, we are taking a big step towards improving access to justice. It will help reduce delays and costs. And by making documents available online, justice system will be more transparent, helping citizens and businesses to understand their rights and contributing to consistency in case law. In the European institutions, we began our joint journey towards e-justice more than a decade ago. The Commission, the Council, and the Member States have cooperated very well to establish concrete, interoperable digital solutions. Let me name just a few. The European e-justice portal, the various interoperable national registers, the work on a common European case law identifier, and the e-codex system for secure cross-border data exchange. I'm also aware that in a number of member states, the digitalization of justice systems is an important policy strand and is already well advanced. Digitalization can guarantee easy and timely access to justice. It can also improve the efficiency, quality, and resilience of court systems, which is good for Europe's citizens and businesses. The possible benefits of digital justice systems during the current health crisis, where social distancing is the new norm, are clear. But the benefits of digital justice are not exclusive to the pandemic situation. For example, making judicial decisions machine readable permits the use of algorithm-friendly justice systems in line with the European Data Strategy and the Commission's policy on artificial intelligence. Artificial intelligence is instrumental for creating robust search facilities that allow better access to case law for legal professionals and the general public. Seamless access to and easy reuse of case law allows for innovative legal tech applications to support the work of practitioners. And the practitioners who use these applications can become more efficient and can reach clients who could not otherwise afford their services. Legal practitioners can also better play their gatekeeper role when using digital tools to gather relevant information. They can advise clients not to bring ill-funded cases to the court. At the same time, legal practitioners need adequate expertise to critically evaluate the output of algorithmic tools they may use. The practitioners need to be aware that the data that likely inform the algorithm output is particular cases is based on societal conventions that could change. And we need to be aware about that. There are evolutions in the society, and we need to be ready to take care about such an evolutions when we are using algorithms based on societal conventions, maybe from the past and not from the actual situation in the society. It has become clear from the COVID-19 crisis that further uptake of new technologies by justice systems is necessary to make them again more efficient, robust, and resilient. Recent data shows that many member states were swift to react and adapt to the new realities brought on by the crisis and introduce ways to communicate digitally, in particular, video conferencing like we are using today for such a conference. Even so, I believe that we need to move forward in a more structured way and with new vigor. It is clearly the right time to work together to make the digital channel a viable way of providing seamless access to justice across Europe and moving forward with concrete actions at national and at EU level. In that regard, the Commission is considering adopting a communication on the digitalization of justice in the European Union by the end of this year. My team intends to propose a new approach to the digitalization of justice and put forward a toolbox of measures to foster digitalization both at the national and at the cross-border level. Such measures would focus on establishing a framework of specific actions, take stock of how the EU could help financially, and identify needs for further legislative measures. I want to underline that digitalization of justice at the level of the Union is very closely linked to progress at national level. Therefore, I would like to strongly encourage national governments and judiciaries to adopt an ambitious approach towards the digitalization of national justice systems. I also hope that in the aftermath of the pandemic, member states will identify the digitalization of justice as a priority in national recovery plans. I have said that 2-3 times to the different ministers of justice in all the member states within the different justice council. And I must say that I insist also in the Commission that we will ask to the member states to be very attentive to the fact that, of course, we need to work on the green transition, the Green Deal. We need to work on the digital transition. But the digital transition is not just for the businesses, it's not just for the citizens, it's also for the public administration, and certainly for the justice system. Because we have seen in the last decades many progress in some specific administration. I'm thinking about the tax administration. I was in charge about the tax administration in my country, but we have seen different evolutions in the member states about the justice system. I said there are some member states with a huge investment in the digital tools for the justice system. There are others maybe with less investment. So again, and I count on you to express the same message to the different authorities, I'm hoping that in the national recovery plans dedicated to use the new financial resource at the EU level, I'm thinking about the next generation EU, it will be possible to identify digitalization of justice as a priority in the national recovery plans, because it's very important to be sure that it's not just dedicated to other activities, but also to the public services and certainly to the justice system. But having sufficient finances is not enough to ensure successful digital transformation, which constitutes a major shift in culture and depends on political will. But of course, digitalizing the justice system does not solve every challenge. It even creates new ones that we need to consider carefully. Let me give you, to conclude, a few examples. First, disadvantaged court users can lack the means or skills to access a fully digital justice system. Member states need to put in place special arrangements for such users. They must make sure that no one is left behind by implementing institutional, organizational, and financial measures. We need to support some possible users because there are differences in the capacity to have access to the fully digital justice system. Second, authorities must guarantee the right to a fair trial. Particular attention is necessary in digitalized criminal proceedings to avoid any interference with the rights of the defense, including private communication between the client and its lawyer and the right to access material evidence heard by the court. Third, court staff and legal practitioners should get support to improve their digital skills. So, ladies and gentlemen, digital technologies offer major potential to improve access to justice. I look forward to putting in place a fruitful cooperation with stakeholders and legal professionals at national and EU level on defining a common way towards an ambitious strategy on digitalizing justice. And I want to say that it will be a main topic in the next weeks and months when we will analyze the national recovery plan. But again, we are working on some main issues like the rule of law and the culture of the rule of law in the entire Europe, but also, to be very concrete, the digital justice system. And I'm sure that I will receive maybe some ideas and some proposals coming from your conference. So I wish you all the best for this conference. And again, I look forward to working together on these important topics in the years to come, because it's very important that we try to convince all the participants, not only in your conference, I'm sure that they are, but in the entire Europe, the participants of public debates, that the rule of law is an important element of our union, and of course that an efficient, not only an independent one, but also an efficient justice system with digital tools, it's also a very important element of the way to organize the society at the EU level. And thanks a lot for your invitation again, and thanks for your attention, but I wish you a very fruitful conference. Thank you.
Well, thank you, Commissioner, for this truly inspiring talk, which has addressed many topics which the ELI has been working on and will work on in the near future. We had a fruitful discussion already earlier in the year where we stressed that we have these three big priority areas, which is rule of law in the 21st century, digital life in society, and also sustainability and climate protection. So I think the topics you addressed already fall within two of those pillars of our future work. And we're really looking forward to the dialogue with the European Commission on these topics. I would now like to invite our participants to pose questions to the Commissioner. I understand the Commissioner is available for questions and for a discussion and an exchange with the members of this organization. We are on Zoom webinar format, which means that you unfortunately cannot appear on the screen as a tile, but you are kindly asked to type in your questions into the Q&A function, which you find at the bottom of the screen. So please click on the Q&A function and type in any questions you have for the Commissioner. And I see there's already a first question in there posed by Frederick Zoll from Poland. And I read the question. In my country, Poland, the situation is getting worse. The government has announced a fundamental reorganization of the judiciary. There is a general fear that this reform will destroy the last remainings of the judicial independence. The new reforms try to circumvent the interim measures of the Court of Justice concerning the disciplinary chamber. To what extent the EU is able to influence this development and to enforce the observance of the rule of law? We have a feeling that the EU is starting to somehow tolerate this turn of events. Commissioner, this is a very important and difficult question, please.
Well, first of all, I've expressed our intention, our commitment to publish this month a report on the rule of law. And of course, in the report on the rule of law, you will read our appreciation of the positive evolutions, but also of the negative evolutions in all the member states. I don't want to say now what could be or should be the report on Poland, because we are in discussion with the Polish authorities about the possible elements of the report, but we will publish that in the other month, so we'll see a very concrete appreciation of the positive and negative evolution in all the member states, but so important. But I've said, the report is an additional tool, so it's not to replace other tools. And so we continue to work, just to be concrete, on two elements about Poland. You know that there is an Article 7 procedure at the level of the Council now. It was a decision of the previous Commission to start such a process, and we continue to discuss on the basis of Article 7 at the Council level. We'll have again maybe a discussion next week in the Parliament on this, but certainly in the next Geneva Council this month, we will have a state of play about the Article 7 and the way we are considering the different reforms. But that is one possible other tool. The other possible tool is the infringement procedure. And of course, you know that the previous Commission and the actual one have decided to start different procedures before the court. First of all, I have asked the Commission to go to the court to have interim measures about the disciplinary proceedings and procedure in Poland. And we have had a success. In the beginning of April, we have received a positive reaction of the Court of Justice to say that it was very important to stop all the disciplinary procedure in Poland against the judges on the basis of our requests, and it was with a clear decision of the Court of Justice. But we have also sent a letter to the Polish government about the last law on the justice system, the so-called Muzzle law in the Republic. And I must say that we have engaged a dialogue with the Polish authorities on that, and we will decide in the next weeks about the necessity to go again to the Court of Justice. So we are continuing to use all the possible tools about the situation in all the member states and certainly in Poland. So of course, we are not in a position to say that we don't want to continue to act on this. So the rule of law report will be a document, of course, presenting the situation, but we continue to work on the basis of Article 7. We have engaged a dialogue with Poland about the last law, and we'll see in the next weeks if it's needed on the basis of the answer of Poland to go back again to the court, and if it's a real need to go to the court, we'll do that.
Thank you very much, Commissioner, for that reply. I will read the next question, which is posed by John McGowan. How do you feel the digitalization of justice will impact privacy of the parties involved?
What I said, we need to take care about the different possible effects of the digital justice. It will be very efficient to have investment in digital technologies for all the different actors in the justice system, for the judges, for the practitioners, for the citizens, because it will be more transparent, it will be more efficient to have access to different case law and so on. But of course, in the use of the digital instruments, we need to take care about the privacy. We need to take care about, I said, the relations between the lawyers and their clients, and to be sure that it's possible to continue to have real confidence in the relations between the lawyers and their clients. And we need also to take care about the possible use of artificial intelligence to take a decision in justice, because I want to be sure that at the end of the process, we have a human being taking the decision. Of course, it's possible to use different tools. And it's all the time an appreciation of a balanced system between the protection of individual rights and about the privacy, about the personal data, and an efficient way to organize the justice system. And it will be an important debate on e-evidence at EU level in such a way, because we will start as soon as possible a trilogue with the Parliament and the Council about e-evidence, so a direct access to the providers in another member state to receive digital evidence, because you know that in maybe 80% of the criminal cases, we need to have an access to digital evidences, because we are more and more using digital tools, of course, but the criminals are also using more and more digital tools. But so I'm very committed to that. In certain level, I have a problem myself, because I need to give more efficient tools to the justice system, but I'm also in charge of the data protection at the level of the Commission, and I'm also in charge of the rule of law, and in the rule of law, of course, on the protection of the individual rights and the fundamental rights. So we need to find a way to have a balance between both priorities. Or it's possible to be more efficient in the justice system, but with a real protection of personal data, privacy, and fundamental rights. And so it's the reason why we are very open to discuss with many stakeholders on this and to receive many reactions, like we have organized for the annual report on the rule of law, and we will do the same for other kinds of initiatives. But it's true that the digital tool is very efficient, but with some dangers. So we need to take care of such a kind of danger.
Thank you very much. I read a question from Christian Twig-Flessner. Christian asks, I hope you don't mind a slightly different tack. There are clearly concerns about the way judges are targeted both in current and former EU countries. What can be done to restore respect for the judiciary among the public media? One only needs to recall the attacks on ELI's current first vice president and the former president of the Supreme Court in the UK, and politicians to ensure that judges cease to be unwarranted targets.
I don't want to repeat what I've said about the situation in Poland, but when it's needed, of course, we need to act. And sometimes it's needed to go to the Court of Justice if we have the more than the impression that there is a real problem with, to give an example, the disciplinary procedures about judges. But more than that, of course, it's very important to work on two elements. It's true that it's very important to have an independent judge. But, and we need to explain some more maybe to the citizens that it's a real add value to have the chance in Europe to go to an independent judge if you have a conflict with another citizens, with the businesses, or with the state, or with the public administration, and not to be in the hand of a non-independent judge. But of course, it's not enough. We need to sort to organize a process to have an independent, but also an efficient, qualified judge. So we try also to work on the training of the judges and the prosecutors and other professionals to be sure that we have a real efficient judicial justice system. But to answer more precisely to your question, it's again more a problem of culture. how it's possible to install in Europe a real culture about the rule of law. And the rule of law, you know that the reason why I said in my remarks that it's maybe the most important element, because if you have the rule of law, the fact that everybody needs to full respect for the law, and if it's not the case, you have the chance to go to justice, to an independent, efficient judge. That's the reality that we need to explain more everywhere in Europe, and we need to install a culture about the rule of law. And in some member states, maybe due to the new mechanism that we are installing, the annual report on the rule of law, we'll have the opportunity to start a real discussion on this. We have seen in the last decades real discussions in many member states about the budgetary situation. We have seen, I said, discussions on many structural reforms, but not so much about the values and the real capacity to change the way to think about the rule of law, to think about the role of the judges, to have more respect maybe for the justice system and the judges in one society, is to install a real culture of debate about that in the society. It's not enough to publish a report in Brussels. It's not enough to organize a conference with some specialists. It's very important to go to the national parliament, to go to the national civil society, and to try, year after year, to install a real culture about the rule of law. And I've said to the president of the European Law Institute that it's very important to try to explain better to the citizens directly what is the add value of the rule of law, what is the add value of an independent and efficient judge, because it seems to be far from many citizens, but in the reality is closer. And so to answer to your question, we need to work year after year to a real development of a rule of law culture at the local level, at the national level, in the member states, and not just to concentrate the debate in the EU institutions.
Thank you very much. I read a question from Robert Bray, who's asking, one of the ELI's projects conducted in collaboration with the Fundamental Rights Agency relates to access to justice and human rights and environmental due diligence of multinational corporations. Knowing that the Commission is due to come out with legislation in this area and that the process of consultation has not yet been completed, what are your personal ideas about this proposed legislation?
First of all, about access to justice, I don't want to repeat what I've said. We are working on access to justice, and certainly through the digital technologies, but there are many other initiatives, because we need also to be sure that, to give an example, all the victims are ready to go to justice with a real confidence in the first contact that they need to have with maybe the police agents or to other kinds of institutions. And we have proposed a new victim rights strategy, you know that, in the last months, to be sure that it's possible to give to all the victims in Europe a real access to justice, and certainly to the more vulnerable citizens, because the Minister of Justice of Austria, Zadić, said that we have seen an increasing of domestic violences in the pandemic in the last months, and how it's possible to have access to police or to justice or to other kind of social institutions during the pandemic if you are blocked at home and you are a victim of violence. So we are working on a lot of things on this. But more concretely, when you spoke about the sustainable corporate governance, in fact, and the obligation to the companies to do more about climate change, but also about social issues, about human rights issues, I'm committed to come next year with an initiative on that, a legislative initiative. And so we are working on two parts. The first one is a due diligence on the supply chain. So to be sure that it's an obligation for the companies to verify the situation in the supply chain. Not to say it's not my business, because I'm just a European company. I don't know what has happened in the rest of the world. No, if you have a supply chain, you need to verify the situation. And again, not only about environmental issues, but also social issues. What are the international conventions coming from ILO about the workers, and salaries, the work conditions, and so on, but also human rights. And so the intention is to come with an initiative asking to have more concerns, not only about the shareholders, but about all the stakeholders, the workers, the local communities, the different kind of actors in the supply chain. But the second element is about the director's duty. How it's possible to ask to the board of the companies to take more attention to the medium and long-term strategy and not only the short-termism on the financial reserves, again for the shareholders. So that's also an important element. And we are working on those. So we have launched now a consultation on this. And after 2 studies on this due diligence and director duties, again, I will come next year with a real initiative, a legislative initiative, because you have seen that there are some initiatives at the national level. Now there are many discussions in Germany about the situation, sustainable corporate governance and possible due diligence on the supply chain. I have discussed with some German ministers on that, and we have the support of the German presidency to take also the initiative at the EU level. So it's a clear commitment. We will come next year with an initiative, and we are in the preparatory works for the moment on both sides, due diligence on the supply chain and director duties.
Thank you very much. I have another question from Frederick Zoll. Mr. Commissioner, do you think it would be helpful if the ELI would adopt an instrument on independence of the judiciary, which would restate the most important principles, providing a guideline and a system of reference for the European countries?
It's all the time useful, but I want to say that you will see maybe the first report on the rule of law in some weeks from now, and we'll start a debate on that. So maybe it will be possible to have a certain level of criticism about the process that we use for the preparation of such a report, because we have tried to put in the report some reference. I said from the Court of Justice in Luxembourg, but also for the Court of Justice for Human Rights in Strasbourg, from the Council of Europe. We have some clear definitions in the different ways, and certainly about the independence of the justice system. And we will explain what is the situation in all the member states. So maybe on such a base, it will be possible for the second report for your organization to come maybe with some proposals to say what are the possible ameliorations of the definition of the standards about the independence of the judiciary, and maybe, of course, about the situation in the different member states. But you will see that we will come with such a report this month, and maybe on such a basis, it will be very important to receive your remarks, your comments, and your reaction. I know that it's a first report, so we'll have a lot of criticism, certainly from the member states, or some member states, but we are very open to make some progress in the next report next year, and it will be an annual cycle. Again, the goal is to install a real culture of the rule of law. So it's maybe better for ELI to come in the next month with some remarks and some proposals to have a better approach again next year and in the near future, in the next annual report. That may be the best way to work.
Thank you very much. I have a question from Mustafa Ibaid. In light of all these challenges related to digital transformation, which face the whole world and the European Union in particular, is there a tendency in the European Commission to create a position that can be called the European Commissioner for Digitization, to contribute to laying the foundations and appropriate strategies and coordination between the countries of the Union in order to organize the transformation process digital at the European Union level?
But to be very concrete, we have started this new commission with the Green Deal, so the first document on the table of the commission. And then in February, we have organized a presentation on artificial intelligence and data strategy. So we have the main document, and we have organized a consultation on AI, and we are working on the data strategy with Michael Vestager, with Thierry Breton in the Commission, and I'm more in charge about the human-centric approach on all those issues to protect the fundamental rights and to avoid any discrimination. But to be very concrete, in the next generation EU, so the request from the Commission to receive capacity to spend more money faster after the pandemic, there are two priorities coming from our position before the pandemic, and we want to continue with the two priorities after the pandemic. It's the Green Deal again on one side, and the digital transition on the other side. So we'll ask, to be concrete, to the member states in their national plan, recovery plans, to pay attention to the Green Deal. We ask 30% of the expenditure dedicated to Green Deal, but we'll ask also to have a real dedication for the digital transition. And I said during my introductory remarks that it's very important for the member states to think about the digitalization of the public administrations and certainly of the justice system. We have different levels of digitalization in the different member states. And so it's a common approach from the Commission. We don't want to have one specific institution in charge of this. There are two main priorities, Green Deal, and we are searching, if you have an idea about the name for the digital transition, like we have put forward Green Deal for the green transition, but it will be a common engagement for all the commissioners, and we ask to the member state to do the same, to be sure that in all the different plans for the new world, well, I've listened to so many comments about the way after, the world after the pandemic, but the world after must be a world with a green transition and a digital transition. And it's a commitment from the entire Commission, but now we try to ask to the member state to do the same and to have a real dedication to the Green Deal and the digital transition in all the different investment plans, the recovery plans at the national level.
Thank you so much. I now take a question from Mark Schmitz. Regarding the enforcement of court decisions in civil matters, there is an urgent need for legal provisions regarding the enforcement on digital assets, for example, cryptocurrencies. There is no national legislation available till now, and it should be necessary to get a harmonized legislation in that respect right from the beginning on EU level. Are there any legislative initiatives that are planned in that respect?
But of course, when we have seen some national initiatives on different issues, we have tried to organize a sort of harmonization at the EU level or a sort of EU initiative. It was the case I said about the sustainable corporate governance, because there are some texts in France, in other member states, now a discussion in Germany, and I'm sure that it's very important to come next year with such a kind of proposal at the EU level to have a cross-sectoral approach for the sustainable corporate governance. The same for the digital world. We have launched a consultation about AI. We'll have a discussion at the end of this year about the Digital Service Act to see what are the needs to change the Digital Service Act. But we are also in discussion about the safety of products due to more and more use of AI in different products and services. We'll have the same discussions about the liability. What kind of liability when there's a use of AI in different products and services? And why not one day to have a specific legislation of some financial products, but that is more in line with other colleagues in the Commission in charge of the financial products. But we need first to see what are the needs to intervene, because of course we don't want to have European legislation at all. And for the moment, we are more working on the data strategy, on the different ways to change the Digital Service Act and to have a new provisions on, again, safety of products and services and liability. And to me, it's very important also to work on, I said, the human-centric approach, so to be sure that we'll avoid any discrimination, any violation of fundamental rights in the way to use digital tools, AI, or more in general, I would say, the digital technologies that we are seeing on the market. But why not maybe one day a legislation on the financial products coming from the digital world? For the moment, I don't see a real intention at the national level to do that. I'm not sure that there's a real intention in some services at the EU level, but if we have some proposals, why not? We are very open to analyze the situation to see if it's needed. But again, we are more working now on the data strategy and the way to have a framework for the use of AI, like safety, liability, and other kinds of elements again against discriminations and fundamental possible violations of fundamental rights.
Thank you so much. I hope we can take at least one more question.
One more question, yes, we are not so.
One more, okay. So then I take Lord Thomas, who asks, most litigants and most victims of crime need legal advice if they are to use digital means to access justice and to have a fair hearing when they seek to uphold the rule of law. What more can be done to ensure that those without the money to pay for a lawyer have such advice, for example, through online provision?
Well, but I said we need to take care of different kind of problems or risks when we are using digital tools. And certainly there are some vulnerable publics. And it's very important to ask to the member states, but we have also the capacity to do something from the EU level to try to help those vulnerable publics to have a real access to justice in general, not only due to the presence of digital technology in general, but certainly when we are using digital technology. And in the victim rights strategy, we have emphasized the situation of vulnerable publics. And we are sure that we need to do more to support the different vulnerable publics in the access to justice. And of course, access to justice, that means also access to some lawyers, access to some advice, to have a help to go through the different channels to the justice system. And again, it was said by the Austrian Minister of Justice, during the pandemic, we have seen some new evolutions. She said domestic violence, it's also possible to say more and more criminality on internet, cyber criminality, but also different kind of crimes, racism, xenophobia, harassment on different social networks due to the situation during the pandemic. And there also, it's very important to try to help the victims of those crimes to have real access to justice, but to give another example, access also to the different platforms to be sure that it's possible to have a very quick reaction if there are some messenger with racism, xenophobia, and other kind of crimes. So of course, it's very important to think about the way to help different publics when we are using different new tools. And it will be a challenge in the near future to work more and more with the platforms on internet, the social media, to be sure that they have the capacity to react very quickly when we have real problems with different sort of crimes on internet, but also in the real life. It's also very important to give a support to the vulnerable publics. And it's a part of all action at the EU level. It's a part also of our request to the member states when they will come with their recovery plan to pay attention, not only to invest in digital tools, but to invest also in the support to the vulnerable public to have a real use of those digital tools.
Thank you ever so much, Commissioner, for being available for this keynote and also for the debate. That really gave us some extremely valuable insights into the work of the Commission. I realized there would have been more questions in the Q&A, but we understand your time is limited. We are very grateful that you made it possible to be here for so long. I personally found it in particular fascinating how you stressed the need for there to be a culture of rule of law. I think this is really the most important thing. It's not sufficient to have just things written black on white on a piece of paper. It needs to reach the population. It needs to reach the different groups of civil society. And it will be particularly challenging. And I personally believe that also there, digitization can play an important role. Many parts of the population, in particular the younger generation, we reach them most easily by digital means. And I think everything what you mentioned, is so important to have all these different elements in order to build up a true culture of rule of law in Europe. And we're extremely grateful to you for all these insights, and the ELI will be discussing many of the topics you addressed over the coming days. And we hope that we stay in close contact and that we can, once the rule of law report is out, also provide more helpful input to that important debate.
Well, thank you very much. It will be a pleasure to receive your input after the publication of such a report. And I said that we will pleasure to work together on the way to instill it through such a real culture of the rule of law in the entire Europe. And we need to explain more. What is it for the citizen, the rule of law? So there are some people thinking again that it's very far from their daily life. And it's not true. There is a real risk if we don't organize such a real culture of the rule of law in Europe. But thanks again for your invitation, and I'm hoping that we will have the opportunity to discuss maybe the real meeting in the near future if we have some progress in the fight against the country. Thank you very much.
Wonderful. Thank you very much again, Commissioner, and all the best.
Thank you. Bye-bye.
Bye-bye.
Thanks.